state of disaster declared by governments been found to be valid, but several of the regulations put in place after that infringed on the rights of individuals. Let's take a closer look at Judge Norman Davis's ruling now, what it means for you and I. Speak to the attorney, Dr. Justin Ramages. He joins us now by Skype. Dr. Ramages, good evening to you. Thank you very much indeed for your time. There's a big conversation around the legal concept of rationality. What is rationality in terms of the law?
Thank you for the question, Stephen. So in terms of Section 36 of the Constitution, one of the elements that needs to be tested is what lawyers call a means and an ends test. What that really means in application or practicality means the decisions you make must reach its outcomes. For example, the restrictions placed on people or the limitations must result in the suppression of the curve, the protection of the state infrastructure in order to combat COVID. So that is essentially the rationality test in a constitutional perspective.
So when a judge looks at regulations like this, what test are they applying? What question are they asking about rationality, the regulation and the Constitution?
Sure. So in its practical form, the judge is looking at one of the regulations allows for, under level 4 at least, allows for exercise during the times of, if I recall correctly, 6 and 9 a.m. in the morning. So you can run and exercise, but you can't go and surf. So is a restriction on surfing, by restricting surfing, will it result in the suppression of the curve? It's doubtful, unless they have scientific information which argues otherwise. So that is essentially the rationality test.
Okay, there's going to be a huge debate around this ruling. I mean, the debate's already started. We don't know what government is going to do next about whether these regulations are rational. Do you have a view? Are they rational? And I would imagine, I mean, one of the arguments put forward by the judge is that to say that, for example, when it comes to funerals, if someone is in a very bad way, they're about to pass on, they're about to die, no one's allowed to come and visit them, but when they die, 50 people can cross provincial borders for a funeral. I mean, there's going to be a huge argument around that.
Sure. And I think that's a big debate. I think what we need to appreciate that this matter was brought on urgency. And so when you bring an urgent application in front of the court, there's dispensation when it comes to timing considerations and evidence. So in my view, and you'd hear from the body of the judgment, there's been little evidence submitted before the court to make a decision on rationality. So if we put a pin in that and we actually start to debate these specific regulations, yes, the judge is of the view that the wording actually used, if someone is terminally ill, you can't go and visit him. But as soon as he passes away, you're allowed to congregate at a funeral. But the point is that if someone's terminally ill, generally they're at a hospital. And if you look at the restrictions and regulations, it's a limited area in which high levels of contamination could be possible in a hospital specifically. So you have a higher chance of getting it at the funeral, but I mean at a hospital. But there has been incidences. I remember there's a report on the 1st of May, if I recall correctly, where there was a funeral attendance at Nelson Mandela Bay, 2 funeral attendances. The effect of it was 54 people got infected and a person died. So there's massive debate around these regulations and the judge's views.
Okay, so that conversation will continue. If all of the regulations have to be rational for the entire thing to be considered rational? What I'm trying to get to is if one regulation is struck down, is all of it null and void or just that regulation?
No. So it would be that particular regulation insofar as apply. So what the judgment does is it says, look, there's certain regulations which are rational. Limitation when it comes to restaurants, fitness clubs, closure of borders, and specifically tobacco, because that matter is being heard, if I remember correctly, on the 22nd of June. So those are kept intact. However, the other provisions which the judge has not specifically identified is mentioned 3 or 4, if I remember correctly, one being hairdressing, the other being terminal illness and funerals, service delivery when it comes to food parcels. He wants the executive to test the rationality of these provisions against the constitutional rights which are found in the Bill of Rights of the Constitution.
Okay, I mean, we all know that there's likely to be appeals and all sorts of things are going to follow. One government has some time to consider that. The regulations we need to keep re-emphasizing are still in place as we speak. One of the things that the judge said is that he gave the impression that he didn't feel government had taken this seriously enough. So the minister herself hadn't actually replied. It was the Director General. At one point, the Director General's comment around the means and the ends didn't actually make much sense. Was given a chance to correct herself, didn't. All of those things. If it goes to an appeal, can their arguments be changed? Because often you're not allowed to actually introduce new things in an appeal. If this case were appealed, would government be able to go back and correct some of the mistakes that this judge has claimed they made?
Sure. I think it gives them a very good second bite at the cherry. What they're going to be providing is more substantive evidence to prove that the regulations, this is assuming that they are of the view that all the regulations are constitutionally valid. They'll give appropriate supporting information in order to make a more substantive case instead of relying on platitude, as was done in the case. And maybe this time the minister will sign the affidavit himself instead of the Director General. But what we do know is that the state at the moment is undercapacitated. We see there's a failure by the state to make appropriate submissions at an appropriate time. They can't comply with the appropriate timing considerations when it comes to litigation, and that puts them at a disadvantage. So yes, the short answer to your question, it will give them opportunity to present a more substantive case if taken on appeal.
There are going to be other cases. The Democratic Alliance has got a case. Freedom Front Plus has a case. They've all got political intent. That's fine. That's their right. What happens if this case goes to appeal and then those cases are heard? Could they all be combined into one case? I mean, you don't want judges, because all of this is happening so quickly, so everything's on an urgent basis. You don't want different judges coming to different views on essentially the same set of regulations.
Assuming that they are the same and they're not distinguishable, sure, they can be heard on those bases. But if we look at it practically, they have 14 business days in which to consider. So considering that there's a public holiday, we might see this matter only start to be resolved or finalized on the 24th of June. If we look at government's trajectory in lifting the restrictions on the regulations, we might find ourselves in the level 2 phase. So all these applications that are being brought might actually be historical or moot, if you really want to call it, if we go forward. And there's level 2 restrictions which take away the rug from under the parties contesting it.
Dr. Justin Ramages, really do appreciate the time, and attorney at TGR Attorneys with the latest on those regulations.